From sunrise to sunset, all day and night. Power Radio.
A very good morning to you, ladies and gentlemen, and thank you so much for taking the time to join us on the Power Morning Drive Show with me and Wanyoike. And we had promised you that we were going to have a conversation with the lawyer of Sharon Otieno's family about the Obado case and the aftermath after he had been, confirmed guilty by Justice Cecilia, what's her name? Cecilia Githua, yes, by Cecilia Githua. Judge Cecilia Githua did definitely give a 4-hour-long judgment following the Obado case. I want us to listen into that. Judgment by Cecilia, and then we will come back because we are seated with the man of the hour himself, Mr. Victor Hezekiah. He has been the family lawyer of Sharon Otieno's family in these proceedings. Let's take a look and we'll be right back after this.
I am satisfied that the circumstances presented in this case, taken cumulatively, form a chain so complete that there is no escape from the conclusion that the accused persons, jointly with others not before the court, committed the offense charged. The evidence on record irresistibly points to the fact that the accused persons with malice aforethought unlawfully caused the death of Sharon at the material time. It is therefore my finding that the prosecution has proved its case against the first, the second, and the third accused persons beyond any reasonable doubt. I consequently find each accused person guilty of the offense of murder, contrary to Section 203 of the Penal Code, as charged in Count 1. Each accused is accordingly convicted under Section 322 of the Criminal Procedure Code.
All right, now let's pan all our attention to the man of the hour. It's good to have you, Mr. Victor Hezekiah. Habari yako?
Thank you so much.
Yes.
Thank you for having me and Wanyoike.
Sure thing.
Yes, niko salama sana.
Yeah.
Nyinyi?
Sisi tuko salama, and we just want to understand, Justice Cecilia Githua gave that, that very, it has been a national conversation now for 8 years. First of all, 8 years feels and seems like it has been a long time coming. I wonder from where you sit as the counsel who was very much involved with this case right from the beginning. Does it feel that it was finally justice has been served, but also does it feel like it was delayed for a while?
It feels good that a decision was ultimately rendered, bringing closure to the matter. Of course, the family has been really patient and waiting for the closure.
Yeah.
So it's good that that ultimately happened.
Yeah.
As to whether there was delay, honestly speaking, I wouldn't say that there was avoidable and avoidable delays in the course of the trial. There has been intervening factors.
Okay.
The matter began in 2018. It took some time to go through the preliminary processes like procuring bail. Remember, in the first instance, Justice Lesir denied bail. Then they had to go to the Court of Appeal to appeal that decision, and that's when it was later granted. That, of course, took time, but every accused person has a right to bail. Then when we got into 2019, it was just shortly thereafter that COVID struck. But even before then, investigation also took some time, and it is necessary that it had to happen. So, because a case of that magnitude, you also don't want to present evidence that is not watertight.
Yeah.
So when COVID struck, I think it of course affected the operations of the judiciary. Then we took not less than a year before now the actual hearing started. And then when we started, Justice Githua has been, I think she has been diligent, in my honest opinion, because when you have 42 witnesses and you have 3 accused persons, every accused person has different set of lawyers. To just get a date that is convenient for everybody, for the court, for the sets of lawyers for the victims, for the lawyers for the DPP, for the lawyers for the victim, and also for the actual witness who is scheduled to come and testify, it's not very easy. So I think she did her best, and I think I would commend her. At some point, she was transferred to Muranga after hearing about 25 or so witnesses. Now, when she was transferred to Muranga, we also took a break of close to a year because the judiciary was still trying to establish whether a new judge could be appointed to proceed with the matter and what that would have meant for the trial, or Justice Githua was to proceed. Ultimately, the CJ directed that Justice Githua to proceed. And that also meant that now for her to manage her matters in Muranga and come back to Nairobi and take the hearing, it was now much more difficult, but she still managed. And from the 26th witness all the way to defense hearing, we were able to secure maybe a block of dates, maybe a week or a few days together. She comes, we do the matter, we take a break again. I don't think there's anything she would have done better that she didn't do.
Oh, wow.
Yes.
I like that. So from the outcome, she did say that, the outcome was based on circumstantial evidence. For my audience, what does circumstantial evidence mean?
The entire case, not just the outcome, the entire case was premised on circumstantial evidence. What is circumstantial evidence? A crime can happen outside here, and then you are peeping through the window, so you are able to see the one who pulled the trigger. In that case, you become an eyewitness to the commission of the crime.
Right.
Crimes also happen where we are not able to get an actual eyewitness, either because investigations were not able to pin them down, or for whatever any other reason. But you see, it does not negate the fact that crime took place. Therefore, circumstantial evidence is relying on the circumstances surrounding the commission of the offense, relying on the chain of events forming the transaction, forming that crime, and piecing it together until you make an inference that this is the person who committed the crime. Nobody saw you, but looking at this and this and this and this put together, we can only reach one inevitable conclusion that you are the one. Yes.
Okay. Now, as you've said, this case was very complex and complicated in many ways. We've talked about 42 witnesses, which everyone had their lawyer. We have 3 accused in this conversation. What was the most prominent piece of evidence? Because I think there were if I remember, more than 300 pieces of evidence.
No, there were a total of 81 exhibits.
Okay.
Yes, prosecution exhibits. There are other exhibits that were also produced by the defense.
And by exhibits, when you talk about exhibits, what are we talking about here?
Exhibit means a piece of evidence that has been presented to court and admitted in court as evidence to support a particular fact or a particular allegation.
Which can take the form of...
It can take the form of a document.
Okay.
It can take the form of a property. For example, like one of the evidence or exhibits that were presented was the motor vehicle. It can take the form of a phone. There were some phones that were presented as exhibits. It can take the form of electronic evidence, which is an extract of maybe phone correspondences, the way we exchange text. That correspondence exchange can be extracted and presented as evidence. Sometimes it can be, depending on the nature of crime, it can also include a gun, it can include a panga. Such like things. Those are exhibits.
So in this case, was there any prominent one that was like, at this point now, there is really no denying? Or all of them?
Remember, we are talking about circumstantial evidence.
Yes.
What it therefore means that no particular piece of exhibit is stronger than the other, because this one gets its relevance only because it has connection to this other one. we are trying to piece things together. So Exhibit 1 relies on the testimony by another witness,
Yeah.
and it relies on how it is connected to Exhibit 23 and such like. So maybe if to strictly answer your question, I would say maybe something like the motor vehicle. There were also the extract of correspondences from some of the accused persons and other people, other witnesses.
Yeah.
Of course, there was the gruesome photos of Sharon and the unborn child. There were photos from the crime scene. I think those were some that could that inevitably led to the conclusion that actual murder happened.
Yeah.
Now, to tie it together with who committed, now those one depended on those other
Evidence.
I don't know whether you want to call them minor evidences. Yes, but it's a matter of piecing together one plus one plus one without picking one as more important than the other.
Yeah.
Yes.
Obviously, this has been a high-profile case, involving a former governor, Obado of Migori County. A lot of conversation surrounding this outcome is that could be the right direction towards the whether it be the holding account high-profile persons in the Kenyan justice system, but as Kenyans being Kenyans, there's also the other faction that is very skeptical about whether this will actually mean what it means on paper. What do you make of these two judgments?
From my perspective as an advocate and a daily practitioner in our courts, it's good to encourage the public to just build trust. Justice takes time.
Yeah.
Justice takes patience. But when we have an independent judiciary, then it is assured it may take time. It's just a matter of time because there are many other factors that determines the speed at which the court moves. But when we have an independent judiciary, then you realize that justice does not depend on your social status in the society. It does not depend on any political position. It only depends on the facts, the evidence, and the law.
Yeah.
Yes.
So then what happens next in terms of mitigation? Are these three accused persons now, by Kenyan law, what happens? Is there a possibility for them to appeal against 81 exhibits of evidence? What does that look like?
In terms of mitigation first, what is currently happening, we are going back to court on 18th for a mention. It will be a mention to confirm whether some reports have been prepared and filed.
Okay.
Some of the reports that will be relied on by the court are there's one called Victims Impact Assessment Report, where the probation officer comes up with a report to explain the impact of this offense and crime on the victim's family. There's also a report as to whether any of the accused person may have been convicted of either a similar or any other offense before. So those are the kind of reports which are now being prepared and to be filed before 18th. After that, the accused persons will be given an opportunity to mitigate. Mitigation basically means that they're given a chance to plead a case for leniency in sentencing. After that, the court will have its day, will render its sentence. Once sentence is rendered, as a right, every convict has a right to appeal. So the accused persons will have a right. As to whether they will exercise that right, that will be their choice.
Yeah.
But the law grants them that right. Appeal, you don't appeal per se against exhibits.
Okay.
You appeal either against a decision by the court. In this case, they may appeal against the conviction, or you may appeal against the sentence. Somebody may say, I'm satisfied with the conviction. I believe that the judge reached a proper conclusion that I am guilty. But I feel the sentence meted against me was harsh.
Yeah.
I feel I should have deserved something like 5 years.
Yeah.
So the judge went overboard by giving me 20 years. So they can choose to appeal either the conviction alone, or they can choose to appeal sentence alone, or you can also appeal both. Yes.
And to which the outcome might look like what? Bail or shortened jail sentence, or what does the Kenyan law say?
When you appeal, there are only two possible, let me say there are three possible outcomes.
Okay.
Either your appeal can be allowed,
Yeah.
your appeal can be dismissed, or your appeal can be partially allowed and partially disallowed. So if you appeal against a conviction and sentence and that appeal is allowed, then it means that both the conviction and the sentence will be set aside and you'll walk free. If your appeal is disallowed, then it means that your conviction will be upheld by the Court of Appeal and your sentence will be upheld by the Court of Appeal. If it is partially allowed and partially disallowed, then the Court of Appeal will be very clear as to what aspects of your appeal have been allowed, which means that in this area, the Court of Appeal has disagreed with the trial court. And which aspects of that appeal will have been disallowed, which will mean that in those areas, the Court of Appeal will uphold the decision of the trial court. So those are some of the possible outcomes.
Yeah.
But every decision is appealable.
Yeah.
And every appeal can either be allowed, disallowed, or partially allowed and partially disallowed.
How do you look at justice? Because, this is a human interest story, and Sharon Otieno, unfortunately was murdered. So there's no opportunity for her to come back to life. And so I do cringe a little bit to think that we can be having conversations about such a case and say that justice has finally been served. Can we serve justice really if the person that is the one that this case involves? We're talking about a murder here. Nothing really can be done to bring the person back to life. Yeah, isn't it a little bit too insensitive to say that justice has finally prevailed?
Insensitive may be a strong word, but your question is not a simple question.
Yeah.
It's a question that lawyers and advocates and judges and scholars grapple with every day in law lecture halls, in courtrooms, in journals. What is justice?
Yeah.
And I can assure you that I doubt whether there's any consensus among lawyers, including scholars, as to what justice really means. Now, contextualizing it even in the case of murder, for example, let alone even the one for Sharon, even for murder, the question would be, what does justice look like and to who? Are we doing justice to the deceased victim?
Yeah.
Is it justice to the survivors who have been left behind? And who will those survivors be? Would they be the children of the deceased? Would they be the parents? Would they be the friends? What the children would expect from their deceased parent is different from what the pride that the parents had in the deceased child.
Yeah.
So when you say justice has been served, I think that we just reach a common place of saying we can't have a perfect society. We can't have a perfect punishment for a crime, especially for murder, where one has lost his life. And that is why one of the sentences that the law still allows, and it was the only sentence for a long time for convicts of murder, was death penalty.
Okay.
Where the law said that if you are properly convicted of murder, then the only sentence that can be meted on you is death.
Okay.
It's only until recently when our Supreme Court, through the case of Muruatet, you must have heard probably about it, where they said the aspect of the mandatory aspect of death penalty is unconstitutional. Of course, we now have a very radical and human rights oriented constitution. So the Supreme Court said that no. We are not abolishing the death penalty. It is still lawful, but we are now abolishing the mandatory nature of it.
Okay.
So that if the trial court convicts you of murder, but looking at the circumstances, the trial court is of the view that it was not as cruel in its commission, then you can be given either life imprisonment, you can be given 20 years, you can be given 10 years. So we removed the death penalty, the mandatory aspect of the death penalty. But again, you also would want to ask yourself, even assuming a convict was given death penalty, do you believe that serves justice?
It's a complexity, to be honest.
The greatest, the maximum penalty that we can achieve would be death penalty. Okay. But even that one,
Not even then.
you really cannot say that justice has finally been served to the deceased. What about to the living? So for me, I think it is almost impossible to say that, to reach a consensus of what actual justice would look like. But I think that considering the society we live in, considering our human limitations, considering the imperfection of our law and our legal system, this is the closest that we can, making a decision that you are guilty and meting a sentence against you is the closest we can reach whatever concept of justice that we can have, noting that even when we met the maximum sentence of death penalty, still some people will feel it was not justice. Let me give you an example.
Sure.
If you go to the northeastern communities, one of the issues that have been in court is that their concept of justice for murder crime is very different. If they are sure that you are the one, they know whoever committed the crime, they don't ask for him to be equally killed. If you bring a number of camels and community elders sit down and make some agreement and you comply, to them as a community, they will actually feel that justice has been perfectly served, both on the community and on the deceased. But the legal system says that no, when it comes to murder, you can't solve those kind of things out of court. Then the court now says these are the only possible sentences. You cannot say that. You cannot even withdraw such a case in court. So I would say justice has been served, but with the appreciation of the limitation of even understanding what justice really means and to who that justice should be served.
I like the layers you've really explained and gone really into it, which is
I told you it's a complex question.
It is. It is a complex question for sure, and I like that you've also said that amongst your colleagues in the legal
we
practitioner,
have no consensus.
It's all. It's a question that you grapple with.
Exactly.
So how do you? So okay. Anyway, it's fine. You've answered that question. Now, again, human interest. You've been working with the family of Sharon Otieno, the father, the mother, in all this court case, appearing before court. It can be gruesome. It's definitely very mentally and emotionally straining. And I mean, I can only imagine the strain that it has taken. For you as the family counsel, first, what can you tell us about how they are doing right now, their parents? Are they happy with the outcome? Again, going back to the complexity of that question about justice, how are they doing? I know right now it can be a little bit too overwhelming for them to even do statements in press.
We have not yet had a very substantive conversation with them, with the family. And understandably so. That was a very weighty matter for them as a family. They needed time to process that judgment. They needed time just to heal from whatever transpired. Of course, they may have participated in the hearing for the whole 8 years, but there's a freshness that is awakened just by the decision being made and the appreciation that this may be it at the end of everything. There's a way that wound may actually be reopened. So they needed time to process the judgment and they needed that space. As to their reaction, I think other than to say that they have welcomed the judgment, it is only fair and proper that they express their own feelings, their own reaction by themselves, lest I misrepresent their position.
Fair enough.
Yes.
I know you have to leave. As we conclude our conversation this morning, what precedence does this outcome mean for you as a legal professional, but also for the larger legal system in the country?
For me, I think it just reinforces my belief in the judiciary and in our judicial system. as we said before, we have good judges, we have reliable and independent, judicially independent, rather decisionally independent judges. They are there. Unfortunately and admittedly so, there are some elements in our judiciary where there are complaints here and there. But the judgment, to me as a practitioner of law, reinforces my belief that justice do exist and we can actually achieve an independent judiciary. One thing that my seniors have said before is that it's not a perfect system. We just work it out every single day. So if I get a hitch today, that hitch should not inform my opinion on the entirety of the judiciary, because today I will get a hitch, but tomorrow I'll get a success.
Yeah.
So we look at it from that perspective. To the larger public, my only, what I believe, or what I hope it teaches us and it reminds us the same thing, that our judiciary can indeed be independent, and more importantly, that when all is said and done in the court of public opinion, the judiciary makes decisions based on facts, evidence, and the law. Yes, we are allowed to talk on Facebook, we are allowed to talk on social media, we are allowed to talk in our social fora.
Yeah.
But when all that is said and done, court decisions are informed by the facts, evidence, and the law. Yes.
Speaking about the public, are they allowed to come to the public the hearings? Are they public?
Yes, court.
And where
sorry,
is
proceed.
that? Yeah.
Court proceedings are public proceedings,
Okay.
unless otherwise directed by the court.
Yeah.
There are some nature of proceedings, but there are some proceedings that by their very nature, they require some privacy. For example, where we are having children matters, a defilement case, for example, to protect the interests of that child, then the court may want to conceal, or rather to make those proceedings private, and only limit it to the primary participants.
Yeah.
In this particular case, there are some witnesses who, in the course of their testimony, the media was prevented from airing those testimonies live, but some were just public.
Okay.
There are many members of the public who joined. You even remember in the judgment reading itself, we had the courtroom was packed.
Yeah.
In fact, they were given even a different room where a screen was put because it's a public.
It's very
proceeding.
yeah.
So
of public interest.
Yes. Especially now for this one, which had a lot of public interest in it.
Yeah.
You go to Milimani or whichever courtroom. A case can be tried from whichever court. If there is no restriction, then you are allowed to participate as long as you abide by the rules of the court. Be there, be silent, don't cause any trouble, don't cause any interference. Don't interfere with the witnesses. Yes.
So by law, categorically, it's happening at the Milimani courts.
This particular trial happened in Milimani.
Okay.
But it doesn't mean that all of them happen in Milimani. It can happen anywhere. Yes.
Okay. So then the next, you said the next phase is the
next phase. What we are waiting for is now mitigation. Mitigation is the accused persons, or rather the convicts, being given an opportunity
to
plead their case for leniency in sentence. Then thereafter, the court will render its sentence, and upon rendering the sentence, that will mark the official closure of the trial court proceedings. Then the next phase is appeal, if and should they choose to appeal.
Okay.
Yes.
All right. Final remarks as we close?
Final remarks, just to express my gratitude for the opportunity to speak to the public and to share my thoughts. But also secondly, to encourage the public to continue having faith in our judiciary and to continue working it out. Our judiciary is part of the ecosystem in which we live. The imperfections we see in our parliament, the imperfections we see in our executive, the imperfections we see in our independent commissions, the imperfections we see in our one-to-one relationships, and those that we see in our families are the same ones that we also see in the judiciary. But one imperfection does not mean that the entire judiciary is wrong or is rotten. Let us continue working out those imperfections. Yes, we should not be relaxed with them. But the fact that they are there does not mean that the entire judiciary is bad. We point them out, we address them, and then we just make it better day by day.
Okay.
Yes.
Wow. Thank you so much, Mr. Victor Hezekiah, for speaking to us on Power Radio, and all the best with what happens from this point going forward.
Thank you.
Yes.
Thank you so much, Anne.
Yeah.
Thank you for having me.
Sure thing.
I really appreciate it.